Many of you are probably familiar with community law program. I will just tell you, well, let's first start out with, can you advance a slide, Mercy? Let's just start out with, I like to talk about a few statistics just so that we can get everybody focused on why we're here. 34% of Pinellas County residents are renters. I'm kind of questioning that because with all the development going on in Pinellas County, I'm sure there are probably more renters than that, but that's what the Florida Housing Coalition says. And so, and most of those renters are cost burdened, which means that they are spending more than 50% of their monthly income on housing costs. Housing costs include not only rent, but it also includes utilities, the electric bill, the water bill. And so when you think of that and the clients that we serve, you can imagine how people struggle to pay their rent. And then this next statistic, 3 out of 4 low-income seniors do not have access to affordable housing in Pinellas County. Affordable housing means more than just housing that you can afford. In the housing delivery industry, housing advocacy industry, what that means is that there's certain housing in every community that's set aside, that's considered public housing or that is subsidized by the federal government, which means that people who reside in those houses receive vouchers, and they use those vouchers to pay a portion of their rent. So if 3 out of 4 seniors don't have access to affordable housing because affordable housing is so rare these days in our community, when they are subject to eviction, they really are vulnerable because they are not likely to be able to move to a place that would enable them to pay a rent in an amount that they can afford. They're on fixed income, Social Security. Some seniors get anywhere from $800 to $1,500 a month, and thinking that they have to use that money to pay their rent and all other housing costs is really, really eye-opening. So I just want you to think about that as we talk about why we're here. Community law program, as many of you know, was founded by members of the St. Petersburg Bar Association in 1989. These are the legal services that we provide. The and more means a host of other things. We assist nonprofits with transactional legal matters. We assist people to determine if their criminal records can be expunged. And how do we help people? Well, we help them by coordinating volunteer attorneys to staff advice clinics. We operate about 15 different advice clinics a month on subject-specific topics. Before the pandemic, those advice clinics were operated virtual, in person. Since the pandemic, most of them are operated virtually. And from those clinics, we identify people who really needed extra help, either because their legal issue is complex or they have particular vulnerabilities that they need representation, and we try to match them with other volunteer attorneys. We also have a number of special projects. The special projects are really designed to enable us to meet the greatest needs in our community, which are greatest legal needs are always family law and landlord tenant. And because of those needs, we have attorneys on staff that handle cases. Mercy is one of them, and Nancy, our presenter that you'll be hearing from soon, is one of them as well. So let's look at the agenda. The thing I want to mention about that is well, it's not on here, but when we advertised the CLE, we indicated that we would have an ethics portion. Sadly, the person who was presenting that portion canceled at the last minute. We did not want to reschedule the CLE because we had already rescheduled it because the first person we had canceled on us. So Chris Schulman, who was supposed to be here today, has been working with us in our mediation program since the pandemic. He's a wonderful mediator, a wonderful teacher, instructor at Stetson, and we are going to be getting with him to videotape his portion of the CLE so that we can make sure you get that information and send that to you, and you'll be able to certify your 0.5 ethics credit at that time. So now, without further ado, I'll bring on Nancy, who's going to talk about eviction basics.
Thank you, Kimberly. So let me make sure I'm showing here. Yep. Okay. So a little bit about me before we get started. I signed up to volunteer with CLP in early 2020, not realizing what was to come just a month later. So my volunteer effort has evolved into essentially a full-time position. So I will not be, although I spend a lot of time in the weeds with landlord tenant, I will be reviewing eviction basics. And it's important to note that the intent of the information provided is not to tell you how to represent someone as an attorney. It's to highlight the important areas that will aid in an effective mediation process. So we're going to start with, again, I'm making an assumption here that you may not be familiar with landlord tenant law at all, and that's okay. So the chapter 83 and chapter 723 are the two chapters we're going to focus on. So at a high level, chapter 83 includes tenancies within an apartment, a single family home, and a mobile home where both the mobile home and the land is rented. In contrast, chapter 723 applies where a tenant owned the mobile home is placed on a rented or leased lot in the mobile home park with 10 or more units. And there's a lot more detail to that, but at a high level, those are the two areas of law that we'll be focusing on in these mediations and in the presentation today. Next slide. In this slide, we're going to show you that, that the numbers have jumped. As you can see, in Pinellas County alone, there were over 6,112 to be exact, residential evictions filed in the past 14 months. And there were over 5,000 in the past 12 months. There are 4 judges who are assigned to these cases in Pinellas County. You have 2 focused out of the Clearwater court. That's Judge Carassis and Judge Fettinghouse. And then Judge Kelly and Judge Jagger are located in St. Pete. And this means that each judge receives approximately 100 new cases per month, in addition to the cases that are still pending. And that's a sizable demand on the courts and the judges. So not to mention the families impacted both presently and coupled with the long-term effects of this eviction filing. So the mediation process is a vital component to address and try to circumvent the need for court intervention. Once filed, even if later dismissed or otherwise abandoned, the harm is done to the tenant. Many landlords will overlook a tenant with a blemished record in favor of other tenants without a record. Next slide. Both statutes, 83 and chapter 723, follow summary procedure. So what does that mean? So summary procedure has its own set of rules and timing, and this is what the landlords are held to when they file. So it's a shortened time frame. So all defenses of law, in fact, shall be contained in the defendant's answer, which should be filed within 5 days after service of process. So normally, as you're aware in civil procedure, you have 20 days to respond to an answer. In both chapter 83 and 723, they follow a summary procedure. The tenant has only 5 days, not only to respond, but to also deposit any money that's claimed as owed into the court registry. If they do not do both of these things within 5 days, they essentially waive their defenses. Discovery, only oral depositions are allowed in the summary procedure. And you can ask the court for leave to expand upon that, but that's rarely happens. And then jury trial, where permitted, they can request a jury trial as well. Next slide. Okay, so here you'll see that in the process, there are several main steps that the eviction process flows through. The first is the triggering event. So this could be a rule violation. It could be the failure for a tenant to pay rent on a timely basis. Something happened to trigger this event from the landlord. There is a notice then required in most all instances. You would then proceed to the notice stage. The landlord would then give a notice, and only after the expiration of that notice period would you be able to proceed with the eviction filing. So this is the sweet spot. This is where we're looking to have the pretrial happen and the mediations happen, is during either when the event occurred. So you have a tenant reaching out saying, I couldn't pay my rent this month, landlord's threatening me with an eviction, or where the notice has already occurred. And that's the point where we want to get in and try to get them scheduled for mediation where we can do the most help. Okay, and then so the last step after the court filing, it moves pretty quickly. As we mentioned previously, there's only 5 days to respond. The tenant would respond with any defenses, with the registry deposit. It moves to a final judgment stage, and then the writ of possession. And that's where the sheriff is going to come post the notice to the door. They give a 24-hour notice that they will return. In Pinellas County, it's usually 48 hours, but nonetheless, it's a very short period of time and window of opportunity to address it. So the best stage is to try to address the issues when the event occurred in the notice. Now, with the notice requirement, there's just one, we won't be addressing it here, but there is unlawful detainer. A notice is not technically required there, but in most cases, a notice is required before they can proceed to the court filing. Okay. So because of the timing and how quickly the process moves once elevated to a court action, we must be filed in court within the 5 days, etc. The mediation project will be focusing on that intervention point, as I mentioned. So the pretrial, before or within the notice period, and that's where we see most of our clients as well. Next slide. Okay, again, I won't go into detail here, but some of the top concerns of landlords that you would see in the mediation is unpaid rent. So the tenant fails to pay rent. They don't communicate with the landlord on how they plan to cure this lack of payment. And landlords need to be aware of the notice requirements, and often they fail to provide the proper notice that could result in a dismissal of their court action, and they lose time. So that's very common. Rule violations. So this is another main concern of landlords. But again, proper notice is required, and the type of notice will depend on whether this is a first violation or a repeat violation within a 12-month period. However, even a first violation can allow the landlord to terminate the tenancy if the act endangers the life, health, or safety of other tenants. It's also important to reference the lease for any unique conditions established through contract. So the rule violations, what I quoted, is based on state laws, but there could also be an alteration to that within the lease itself. So it's always important to reference the lease in any mediation process. And the last type you're going to see is a lease termination. So often landlords are choosing not to extend an offer of a new lease to those impacted by COVID. And consideration can be given to whether this is an act of retaliation. A lot of tenants will come forward and say the landlord's retaliating. That's going to be hard to prove, and the landlords have no obligation to extend a new tenancy once it expires. Often tenants feel they have a right to renew the lease, but there's no legal basis for an actual renewal concept, just the decision by both parties, mutual agreement to enter into a new contract or a new lease for an additional term. Or the lease can just extend to a month to month if neither party takes action. But that's another consideration. A lot of times the landlord or the tenant will come forward and they'll say the landlord's refusing to renew my lease. And there's another opportunity in the mediation to try to talk through and come to an agreement to extend. The landlords, however, must be aware that the notice requirements are not only established within the contract or within the state statute, but they could also be at the state and local level. So an example is the Pinellas County Ordinance 22-27 that goes into effect on October 3rd. That does have some guidelines, amount of notice and time that has to be provided. Okay, next slide. Okay, the top concerns of tenant. So the top concerns of tenant are going to include improper or lack of a notice. So notice must meet specific requirements as specified, as we mentioned, by statute or local ordinance, and they must be the proper notice. So a proper 3-day notice. 3-day notice is also the non-payment of rent notice, which is often dubbed 3-day notice. This notice, typically, they're not going to be cured in the court case if it was not filed correctly. So the landlord has to be careful in the date calculation, the amount that they include in the 3-day notice. They need to include the address, including the county of the leased premises, and they have to include the name, address, phone number of the landlord or property manager, where they can pay and cure this issue within the 3 days. So there's a lot of detail that has to be in there. And that's often an opportunity for negotiation with the landlord when they have not provided that proper notice, because if they progress to the court stage, that's often a defense that could get that action dismissed. Also late fees. So as you might be aware, and we'll cover briefly later, is that in City of St. Petersburg, and then again in Pinellas, effective October 3rd, but City of St. Petersburg went into effect back in February of 2020, that there has to be a notice specific to late fees before it can be applied. And we rarely see any late fee notices filed in the court action or provided when requested. So that's another opportunity to talk through with the landlord. A failure to do so, and again, I won't go too far into it, but a failure to do so could result in some fines by the county or city against the landlord. Rent increases, there needs to be proper notices. So there is, if you have you need a 60-day notice and a yearly lease, oftentimes you're going to see this in the lease anyway, but even if the lease does not specify this, there is a requirement in Pinellas County and St. Pete, if St. Pete adopts the Pinellas County rules, of a 60-day notice and a 15-day notice for a month-to-month. So a lot of, I'll hear different attorneys mention that there is a requirement and a month-to-month to give a 15-day notice of an increase in rent. And in fact, there's nothing in the statute that specifically says that. It says reasonable notice, but reasonable notice is often interpreted to be the same notice required to terminate, which would be 15 days on a month-to-month. And that's 15 days, not just any 15 days, 15 days before the start of the next rental period. Okay. The next issue is self-help. So we have a lot of tenants who might experience self-help attempts by the landlord. That is not something uncommon in legal aid to see that. Self-help could, it could be turning off the utilities. It could be changing the locks. And we do see that, and it actually happens more often than you would think. This could result in the landlord being responsible for 3 times rent for each occurrence. So if you have a landlord that shut off the utilities, and then the landlord also changed the locks, there's 2 occurrences. In a counterclaim against the landlord, they could be responsible for 3 times for each of those 2 occurrences, and that can get quite costly to the landlord. So that's another opportunity in the mediation to kind of talk through and resolve it without that risk to either party. You know, and are there any exceptions? Yes, the landlord is allowed to change the locks or remove your belongings without going to court if you have moved out voluntarily or abandoned the property. And again, there's additional rules around abandonment and how to constitute that. So that's just something to be watchful for in the mediation that is quite frequently a concern. And the last is failure to maintain. This is another big one. You're going to see a lot of tenants might stop paying their rent, or if they failed to pay their rent, they've indicated that, well, my landlord didn't repair something. It's not automatic. So the landlord has certain obligations to maintain, and there are exceptions for single family homes. And that's going to be in chapter 8351 of the Florida statutes. but tenants must provide notice before withholding rent. I usually tell tenants, don't ever approach that on your own, because you need to do so cautiously and with the expectation that you're going to have an eviction filed against you, which is going to cause that harm. So the tenant would first provide a 7-day notice to withhold rent. That would be warning the landlord, if you don't fix certain items, that I'm going to withhold all or a portion of the rent based on the severity of the infraction. Of course, it'd be different if they just hear a slight leak in the bathtub versus their toilet is not functioning at all. There's also a 7-day notice to terminate. Now that would be if there's some severe uninhabitable condition that the tenant's telling them that I'm going to terminate my lease at the end of these 7 days. Again, under both of them, you need to be cautious. The tenant needs to be prepared to actually move out on day 8 if the landlord doesn't repair, because you can't force the landlord to repair if they choose not to. But it might give the tenant an option to terminate that lease. In most cases, the tenant doesn't want that because they have nowhere else to go. So they need to be careful with that. And the same with calling code enforcement. Often a tenant will say, I'm going to call code enforcement, or they already have. If the property is deemed uninhabitable, they must vacate. And again, that's going to be, they can terminate their lease, probably waiving off fees, but they'll still have nowhere to go. Okay. A defense to an eviction action could be the failure to maintain, but again, they need to give proper notice, and then that would be a defense that they would provide within the 5 days once they receive an eviction filing. Okay, next slide. Okay, so I'm just going to briefly touch upon, just for an awareness, is that there are several ordinances, well, local municipal code and the ordinance in Pinellas County that either are in effect or going into effect soon. So this is something to keep in mind, of not only looking at the state statute and the language in the lease contract itself, but also consider the City of St. Petersburg Renters Bill of Rights. Again, that went into effect in February of 2020. It requires certain things such as notice of late fees, very specific detail that has to be included in there. If they violate that option, it shall be punishable by a fine of $300 for the first occurrence and $500 for each subsequent occurrence. So we'll often see this where tenants will come in and they were getting ERAP, Emergency Rental Assistance Program, through Pinellas County Assistance, and you'll see a ledger provided and they've been charged a late fee for the last 10 months, but no notice has been provided. That could essentially be 10 different violations or offenses by the landlord. So that's an opportunity to discuss and educate the landlord on their responsibility. It also prohibits source of income discrimination. So the landlord cannot discriminate based on if that tenant is getting subsidized assistance from some program. Now, there is one main difference, and I won't go into detail here, between the City of St. Petersburg and the Pinellas ordinance that's going into effect soon, is that the City of St. Petersburg will allow an exception if that source of income over a certain percent will increase the insurance cost to the landlord. And that's very difficult to prove, but some insurance companies will say if there's more than 20% people subsidized, they're going to have a higher insurance rate. That's allowable in the City of St. Petersburg, but in the Pinellas Code, they do not take into consideration. Also, another difference between the two is that if an inspection is required by a government program, the City of St. Petersburg says that the landlord has 5 days to have that inspection, and if they don't, then the landlord can deny the tenancy for those prospective tenants. And in Pinellas County, I believe it's 10 days. And then a rent increase, again, there's guidelines in St. Petersburg for rent increases. Likewise, next slide, going into Pinellas County, there are similar restrictions. So the Pinellas County ordinance, this was just passed, I believe, on August 2nd, August 3rd in the commissioners meeting. This was passed, it goes into effect on October 3rd of this year. So something to be watchful for. It is very similar. The one caveat here that's going to make it a bit difficult is the cities within Pinellas County can opt out or use their own method. And that's going to be a bit of a challenge to follow and know which applies. But for instance, City of St. Petersburg has their own ordinance. They've had it in place, or municipal code, for a couple of years. they may choose to adopt Pinellas County, or they may continue on with their own tenants' bill of rights. And I won't go into detail on this either, but basically there's a requirement for late fees. They also prohibit the source of income discrimination with the few differences between the city of St. Petersburg. And they also require notice of rent increases. So it's important to look at those and make sure that even though you might have stipulated a certain amount in your lease, that you have to make sure that you're complying also with the statute, the local municipal code, or the county ordinance. Okay, next slide. And this last slide, I will not go into detail on, but I just wanted to make you aware that beyond eviction law, there are some important points that fall within this realm that you might want to keep in mind. So the collection of rent in your residential tenancy is a consumer debt by definition. So in some cases, you're going to find in these extreme cases, and not always extreme, just based on experience from what we've seen, is that there could be a violation of the FDCPA, the FCCPA, the CFPB sets guidelines. And so what does all that mean? So there's at a federal level, there's the Fair Debt Collection Practices Act. And Florida similarly has a Florida Consumer Collection Practices Act. So that establishes certain rules, like harassing someone, calling them on the phone, calling them after certain hours in the evening, maybe calling a neighbor and telling them about the debt and trying to harass the tenant in that way. You will sometimes see that these things are happening. Calling the place of employment. And if you hear those in mediation, those are other opportunities, again, for that tenant to pursue some type of justice. I don't know that it'd make them whole, because each of those have an individual $1,000 cap outside of actual damages. So if they're actually damaged by one of these, so say the landlord put it on the credit report improperly when they really didn't owe rent and they failed to correct this, that could be a suit. And if the tenant then goes to apply for a car somewhere and they get an adverse action notice and the amount increased, there could be an action there with actual damages, because now they were charged a 12% interest rate instead of a 4%. Those are actual damages, so that could increase the 1,000. And I'm going into weeds, which Kimberly told me not to, and it's hard not to go there. So I'm going to stop there. But just to be aware that outside of the eviction process itself, there are additional laws that could protect this tenant if violated. Slander of credit. Consumer Financial Protection did put into effect when the CDC moratorium was in effect. They had a tagline that had to be in the notices that made sure that they knew of their possible rights under these other areas. Okay, and the remedy for that is a private right of action. So it's typically not going to be handled within the eviction action itself, but it could be a separate claim either in state or federal court by the tenant, should the landlord and the tenant not resolve their issues. And with that, I'm going to turn it over to Mercy.
Thank you, Nancy. And I am not sure if there were any questions in the chat. Angela, could you take a peek at that and let us know if any questions popped into the chat for Nancy?
Sure. I don't see any messages right now, but I'll let you know.
Okay, fantastic. And so if anyone has any questions, feel free to put them in the chat. We are actually moving on at a pretty quick pace. So what I would like to do is I'll continue on. And then I think because of our timing with not having the mediation ethics portion at the end, we'll have some time for questions. And then we might wrap it up a little bit early. But just so you know, kind of keep those questions in mind, and then we'll open it up for questions. You can either type them in the chat or use the raise hand feature and we can call on you. So that way we're not all unmuting at the same time. So with that, I am Mercy Roberg, and I'm going to talk a little bit about our Pinellas Eviction Diversion Program, which is a homeless prevention project. Okay, I'm going to give a little bit of history on it, and then I'm going to talk about the particular program for seniors that we're focusing on today. First off, also, I don't know if you've read your Paraclete yet, but there is an article in there that you might be interested in reading about our eviction diversion program. And hopefully maybe some of you saw that. I think it came out this week. So hopefully if you haven't read it, go ahead and read it. If you have, then maybe that motivated you to sign up here today with us. Oh, I see Carl with a raised hand. I'm going to ask you to unmute, Carl, and then you can go ahead and ask your question before I get started.
Oh, I just had the question about whether the statistics were correct that there were 6,000 pending evictions in our county court system or our court system. Is that correct? It looked like it was 600 by the slide. I was just really wondering, because if it's 6,000, that's really shocking.
There are over 6,000 in the last 14 months. The numbers on the slides were how many were filed per month. So in August of 2022, there were 551 new evictions filed. In comparison with April of 2022, there were 341 filed. So you can see the increase as landlords are, choosing to proceed forward with the eviction. But 6,000 was overall in the last 14 months.
All right. That answer your question, Carl?
Yes. Oh.
Thank you. All right, so our Pinellas eviction diversion program, and when we send out the PowerPoint, we will also make sure that the links are included. I think we had a link on one of Nancy's slides, and then I think I have one or two on our slides here today. So this project was actually launched in September of 2022, so 2 years ago. Kimberly Rogers had seen that there was a need for mediation in landlord tenant issues back in 2019. And we had actually started a pilot program in the courthouse where judges would actually mandate mediation. So sometimes landlord tenants would come to court and the judges there in the St. Pete courthouse would say, go straight to mediation. Similar to small claims court, and landlords and tenants there would be able to work out their issues. There was a really high success rate in those mediations. And so when the pandemic started, we ended up having to close that program down just because of everything shutting down. And then what happened was there was a lot of federal funding that came down through the CARES Act and then later through emergency rental assistance programs. And so Kimberly was able to partner with a number of partnerships, 211, Pinellas County, the City of St. Pete, and Pinellas Community Foundation, and work to get these voluntary mediation programs. And what we did during that time was expedite rental assistance to families and single people in need. And so we were doing at one time, and I actually see some of our mediators on this program today, and some of the attorneys that also helped during those mediations in the late 2020 and early 2021. We were able to really get people from not being evicted, all those pre-suit cases. We were doing mediations. I think there were some days that there was 10, I think one day we had 10 virtual mediations at the same time, averaging about 5 a day or about 20 a week. And so there was a lot of success in helping landlords and tenants resolve the rental issues, rent payment issues that were occurring during that time. So what we've been able to do since that 2019 pilot program to where we had rental assistance funding available for Pinellas County residents, and basically using these virtual mediations to help tenants. And so that's kind of how we are here today. And I want to go ahead and just talk a little bit about the program that we're talking about today. So just for your overall information, the funding that came out, CARES dollars first, that funding had been used up. Then there was emergency rental assistance funding that came down. There was an Our Florida program that existed at the state level. And then there was also a City of St. Pete program and a Pinellas County program. All of that funding has been primarily utilized. Those programs have shut down. People have not been able to apply to them for about a month and a half, 2 months now. So we are kind of predicting what Nancy showed in those earlier slides, a rise in evictions, right? So for the last 2 years, the federal government has provided a lot of assistance for people to get back on their feet. Now, we all know COVID is still out there, and we still know that people are, staying home from work because of it, or having to take care of their kids and not able to go to work because of it. But that funding right now is sort of dissipated until we get, further information if there is anything out there. So what we do have now is this new program, which is the Landlord Tenant Senior Mediation Program. And really what we are focusing on is Pinellas County rent increases. If you follow the news, if you look at what has been going on in Pinellas County, even Tampa Bay as a whole, rent increases have been skyrocketing over the last year. Also, if you drive downtown St. Pete, you can see there are just condos just being built, apartments being built on top of each other, and they are not financially stable for our lower income residents. I think an average studio in St. Pete goes for about $1,400 a month, which is just really out of the price range for what has typically been a Pinellas County resident, and typically residents that are over 60. So what we're looking at in this particular program is many of the things that Nancy focused on in Eviction Basics, talking about if we can get clients in for a pre-suit mediation, we can talk about rent increases, we can talk about maintenance issues, we can hopefully get ahead of the issues that some of our seniors might be seeing. So we actually were able to partner with United Way Suncoast to provide some funding to get this program off the ground and to help those seniors. So who we serve through mediation in this particular program, and we just launched it in August. I think we've done about 5 or 6 successful mediations over the course of the last few weeks. And we are looking specifically at seniors. One household member must be over 60s. They do have 60 years old. They do have to be a Pinellas County resident. They have to be named on the lease, and no court cases filed. So this is really that sweet spot where we can get ahead of any litigation and work with the landlord and the tenant to resolve any issues. And then a household income that's at or below 200% of federal poverty. A lot of people ask, well, what does that mean? So that is very household dependent. The income matches up with how many people are in the household. So for example, you might have a multi-generational family, right? So you might have a grandmother or grandfather in a household with 2 adults, 1 kid, 1 adult, 4 kids, and a grandma, something like that. Those households still might qualify. So I often tell people, if you maybe think you don't qualify, but it's always worth a 15-minute call to come in, and not even come in, it's just on the phone call and talk to one of our intake specialists. For the attorneys that are out here, we've actually had attorneys that represent landlords email us directly and say, hey, got this landlord and they're trying to help this client out, but they got to file the eviction just because, maybe your rent's so far behind and stuff like that. So if you serve landlords in your line of work, we always are looking, to sort of work together on some of this stuff. So that's always an option if you're encountering that. And it's a great way for your client to save money, right? So before filing an eviction, right, it costs money to file an eviction, it costs your time, all of that. If you see opportunities for your client to save money through our mediation program, we're always happy to work with you if the client qualifies. So that's been some successful mediations, and also just pre-suit negotiations that we've encountered in this line of work. So just want to put that out there. You can do good for your client and for the tenant. So this is how we serve. So I talked a little bit about this. Free legal representation for tenants at the mediation and for the landlords, right? So it's voluntary, it's free, and we can negotiate maintenance issues, lease renewals, lease termination. right? So a client may say, you know, I can only afford, you know, and I'm going to use this typical scenario. Someone's been living in an apartment for 5 years. Due to rent increases in Pinellas County, they got a rent increase in August or July, effective July or August. An average rent increase right now is $250. So if you are a senior living on a fixed income, let's say your rent was $1,000 a month, you could make it, right? You might be tight, but your bills were paid on time in that right amount of time. If you had an increase of $250 per month, most seniors on fixed incomes would not know where to find that money, right? They are not working, and they probably most likely don't have an opportunity, or maybe even physically they cannot go back to work. So they are not really in a position to just, you know, come up with an extra $250 a month. So that is where we have some rental assistance to help with those experiencing hardship like that. So something we might do in a negotiation would be, okay, you've signed the lease, you're struggling to pay it. What about if the rental assistance covers that $250 for the next 6 months, right? That'll give you the tenant the time to figure out their budget, or figure out if maybe they need to terminate the lease and move out and maybe move somewhere else that's more affordable. Unfortunately, in Pinellas County, $1,000 a month is a great rent rate. So moving somewhere more affordable might not be an option. But some people are choosing to move out of the county. Some people are choosing to move even out of the state with family members. So there's all these different kinds of things that can be negotiated, and that the mediator, you know, in an impartial way can question and ask questions to get both sides to maybe some of that. These mediations so far are not very adversarial, because the landlord is, you know, looking to help the tenant make sure they make their rent payments. And you know, sometimes the maintenance issues can be an issue, but that's really some really interesting negotiation points. Another thing that's fantastic is some landlords are really interested in this help. And I can say that I called a landlord yesterday to speak to this landlord specifically about a client that we have. And the landlord asked for a flyer on these mediations and asked if it would be okay to share it with a few more tenants that this landlord has. And that's the kind of relationships we're looking for. And that's the kind of, you know, like holistic approach where the landlord is now saying, oh, I have, you know, other tenants, and that particular property is a 55 plus property. So that was a really great conversation to have, so that way we can help more tenants that might not know about the program. All right, so how can you help? Or how can you serve? We are definitely looking for attorney volunteers for the pre-suit and even litigation cases if you're interested in taking something in one of our housing clinics. And then also mediators for the senior mediation program. So with that, we are definitely here recruiting and looking to see you know, who might be interested in helping out with this program. We actually have kind of set mediation times already that Angela has put together. So that way, if you see, we'll send out the sign-up sheet on that. If you see that opportunity that, you know, there's time slots that work for you, you can sign up directly. But that is really a big portion of, you know, what the need is in the community right now. So with that, that was almost my last slide. There we go. So I guess I would ask if anyone has any questions about the mediation process, questions about eviction basics. And we definitely flew through that today. I see Carl's hand is still up, but I don't know if that was left over from before. Angela, do you see any more questions in the chat?
Yes, Ms. Kristen Mori said, what is your average time frame that you schedule for each mediation? And I can go ahead and answer that question, actually.
That would be great.
Hi, yes, okay. And I can even, let me see if I can turn on my camera.
Yeah. Can I introduce you, Angela?
Yeah, sure.
Okay. To everyone on here, Angela is a fantastic 3L at Stetson Law. She is also our mediation coordinator for this program. And she's been, I'll tell you, she was a volunteer with community law program for a full year in our housing clinic. And then from there, she became an employee with us over the summer and has moved into this mediation coordination. So if you sign up to, participate, she will be one of your main contacts. And so she'll share a little bit about that process and answer that question.
Oh, thank you for the introduction. Yeah, so if you see me emailing you, this is the face behind the email. And I do see a number of names here who have volunteered and signed up. So thank you so much for dedicating your time. It really means a lot to these senior citizens who need assistance with their rent and their situations. So to answer Ms. Kristen Moore's question, what is the average time frame that we schedule for each mediation? We see most of the time these mediation will take half an hour, but we allocate, I would say, an hour and a half just in case, because sometimes mediation will take longer because this is in a Zoom platform. Let's say one of the parties says, I don't feel comfortable being in the same Zoom room as another person. We want to respect that. And so the mediator will kind of go back and forth between rooms, and that may take some extra time. So we do schedule 1.5 hours. It may go longer, but it also may be as short as 20 minutes as we've seen. I see another question from Ms. Debbie Brown. It says, can I observe a mediation before doing one myself? And Mercy, I'll defer to you to answer that question.
Yeah, I think that's absolutely fine as long as all the parties agree, but that's a great one. It's a great question.
Another question, it said, are the mediations live or virtual? They are virtual through Zoom. And so I will take care of sending the Zoom link to all participants.
I'll stop my screen share and Kimberly's joining us. Well, she's been joining us on video.
Hi, I'm just going to put someone on the spot here because I think, the best form of recruitment is peer-to-peer. That's what we learn in trying to encourage attorneys to do pro bono. Davina has been doing a few mediations here with us in the past couple of weeks. And Davina, would you like to talk about your experience?
Sure. Hi there. I'm sorry, I'm in the office, so I'm going to be a little quiet. Can you still hear me?
Yes.
Okay, perfect. Yeah, I actually just received my mediator's license earlier this year, so they were kind enough to allow me to be part of this. And I've got 2 mediations under my belt, and I've loved it, and it was a really great process. Angela was awesome. Mercy, I've worked with her. She was awesome too. So I would highly recommend it. It was really a great experience, and I look forward to doing a lot more. And the first one was one where they wanted to be in 2 separate rooms. So it did take a little bit longer, it took an hour and a half, but the second one was easy peasy, kind of straightforward. We were done within an hour for sure.
Thank you.
Oh, and in case anyone was unable to see the chat, a question came in that said, can we get a copy of the PowerPoint? Yes, I will be emailing everyone a copy of the PowerPoint so you can click on the links and review the notes, as well as if you want a recording of the event, I will send that out as well.
And I will also say that Nancy and our whole landlord tenant team was a bit modest in terms of how awesome she is. I call her the writ stopper because I think she's probably stopped 50 evictions based on getting the writs set aside and negotiating a resolution that did not result in the trauma of having the sheriff come out and, you know, people getting 24 hours to vacate. So I think if you are considering other opportunities and would like to actually handle cases, Nancy would be a fabulous mentor. We have a housing clinic where you can provide legal advice to tenants. And we also have the opportunity to accept pro bono cases. So I'll let you know about that. And we also have additional training materials that go more in depth on, you know, if you're actually going to be litigating eviction cases. We have a video on that. We have some handouts and pamphlets on that. So handbooks. So I think that we certainly have all the resources you need to support you and however you choose to participate.
And Mercy, a question I think you could answer. Another good question from Debbie Brown. As part of the program, do you have a standard settlement form?
So yes, we have a sort of, I want to say a template that we have utilized to adapt to each mediation, but we do have sort of a standard template to start with. So yes.
And then another question from Ms. Caitlin, and I see that she's on camera. So hello, thank you for coming today. She said, are there any services that offer assistance for businesses to help negotiate leases, specifically a daycare? I'm trying to help a friend and I'm way out of my league.
And Kimberly, are you going to take that one?
Oh, negotiate leases. Well, we have a community council program that assists nonprofit organizations. Is this daycare a nonprofit? Some of them are, some aren't.
Sorry, I don't believe so. They do operate out of a church, but I do believe it's a separate organization that's for profit. So they probably would not qualify.
Okay.
They may just need to hire an attorney to review the lease and go that route.
Probably, yeah. Because if they were a nonprofit, we could try to match them with a volunteer attorney to review that.
Okay, thank you.
Well, there's a lot of great attorneys here on this Zoom.
And
Yes,
then,
if anyone wants to direct message me that could possibly be of assistance, I would appreciate it.
and then another question from, oh, can you hear me okay? From Mr. Carl Grube. Do you need to be a certified mediator in order to serve? So for the landlord tenant mediation program for seniors, yes, we're looking for Florida certified mediators.
And I'll follow that up with in order to, if you're interested in assisting just in landlord tenant issues in general, we do have a housing clinic where as an attorney, you can volunteer your time. And those housing clinics are usually about an hour worth of your time. And then you can also sign up for those in advance. So for example, when I started at community law program, I volunteered once a month in the family law clinic. And that's where I got my first exposure doing pro bono work with Kimberly. So there's opportunities like that in the housing clinic. And a lot of the issues that come through the housing clinic are exactly the issues that Nancy touched on. A lot of people come through with lease renewal questions. A lot of people come through trying to figure out how to resolve maintenance issues on their own. And so you can be a really great source of advice and counsel to those clients, giving them some information on how to proceed and making sure that they aren't in violation of the law themselves.
And I will just add some additional context as to why we are looking for certified mediators in our program. Those of you who are certified probably already know this, but these mediations thus far have been fairly non-adversarial, and that's a good thing. But we're trying to protect the mediators and as well as ourselves in the event that they become adversarial. If a mediation agreement breaks down later on, we want to make sure that our mediators cannot be compelled to testify and have that continued cloak of confidentiality, protection of immunity, all wrapped in the process. So that's why we're using certified mediators.
Oh, a question came in. It says, do you have recommendations for a good mediation certification program?
Our original ethics speaker, Charles Castagna, is a really good mediation instructor. So I recommend reaching out to him. As well as Angela, you probably can tell folks how to get in touch with the ADR mediation dispute program associated with the Florida Bar, with the Supreme Court directly.
Oh, and then a good follow-up question from Mr. Joshua Miller. The mediators can be certified in any area, right? Circuit, family, etc. They don't have to be county court certified. Is that correct?
That is correct.
Well, we flew through this programming. Nancy, do you have anything else to add, or Kimberly?
I do not.
I do not, but there is another question.
Yes, it says, do the volunteer mediators need proof of insurance?
Woo. No, they do not. We have malpractice insurance that covers mediation services.
Well, I have one thing to add. So we did get the CLE accreditation from the Florida Bar, but because we kind of had to split this with the mediation ethics portion, we will, the CLE information is in the PowerPoint when Angela sends that out. So I think you can have a personal choice of either just reporting 1 hour, since the CLE has only been for 1 hour, or you can wait until the ethics portions come out, that comes out, and then you can report that bit all together. So that way you can get full credit for the time and the ethics portion. So I'll leave that up to each individual attorney on what they're going to claim and attest to on your Florida Bar CLE, but I want to make sure that you think about that before you report your hours, because I am not sure if you can go in and report that ethics credit separately later. So I know personally what I'm going to do is I'm going to wait, and then when I get the recording for the ethics, I'm going to then report all my time at that. But someone else may have experienced this previously and know how to do it that way. But just giving you all the heads up on that for your CLE. All right, Kimberly, I'll let you close the program.
Well, thank you very much, everyone, for attending. Angela will be in touch with you with the training, with the PowerPoint and the video recording. And if you ever have any questions about anything or anything else that we do, just give us a call. 582-7480 is our number, and our website is lawprogram.org.